Okay, wait, we got a boosted.
Perpetration of felony counts 2 and 3. The jury sentenced her to life. The jury also convicted her in count 4 of aggravated child abuse, count 5 aggravated child neglect, count 6 tampering with evidence, count 7 through 17 false report, count 19 abuse of corpse, count 20 failure to report a death under suspicious, unusual, or unnatural.
Let me already pause. This judge is a no-nonsense kind of guy. And initially, at the trial, he warned the camera person, don't you violate any rules, which of course they've got to stick to it. But they made 2 mistakes, and eventually the judge was like, out with the cameras, arrest that camera person. That was quite a day, oh my word. So here we are now at Megan Boswell's sentencing, okay? And music by Brian said in chat, Grizzly True Crime, they split the sentencing because the murder one sentence was statutory, but the other charges require a hearing and a pre-sentencing investigation. So she's already been sentenced to life with the possibility of parole after 51 years for the 3 first-degree murder-related charges. And today, she's going to be sentenced on 16 other charges that we have been over before, right? Which is all the lying to the police, abuse of a corpse, and all of that. So you can hear it by the judge's tone. Yeah, he's got no time for this, meaning he's just like, let's just do this now. There's Megan Boswell sitting there with her counsel, and she's got obviously the same lawyer. This is Jean Scott, if I remember correctly. Southern Calibre said, lots of Southern Grizzlies. G does our accent well. Oh, thank you so much. So let's watch this together now.
So we're here on counts 4 through 20 for sentencing today. Is the state ready to proceed?
We are, Your Honor.
Defense ready to proceed?
Yes, yes.
Because sentencing is the first thing that's up, the state has the burden.
Judge, how are you going to handle the pre-sentence report that we made?
Because of the nature of this case, it's going to be exhibit number 1. I normally don't make any exhibit, but I think in this case,
Fine with me.
Thanks,
so,
Judge.
somebody have a copy of it? It's not been marked up? And if you don't, I've got it in the file. I just got to find it. Which file it's in?
Good, we have a clean copy.
General, does the state have any proof?
Yes, Your Honor, the state would call Sheriff Jeff Cassidy.
Raise your right hand, state your name, please.
Sheriff Jeff Cassidy.
Solemnly swear affirm testimony about to give the truth, all truth, and nothing but the truth.
Tell the court your name and where you're employed.
Jeff Cassidy, Sheriff of Sullivan County Sheriff's Office.
And how long have you been with the Sheriff's Office?
Been with them a total of 29 years. This is my 7th year as sheriff.
Okay, and so that means you were sheriff in 2020 during the time of this investigation, is that
Yes.
right?
Yes, ma'am.
And I'm going to take you back to February 2020. Was Sullivan County the first agency to be involved in the investigation of missing child Evelyn Boswell?
Yes, ma'am.
Can you tell me briefly how Sullivan County how the investigation started?
Missing child at first, and then once we found out that the last time the baby was saw was in December, we knew he was already behind the curve there. We was probably 2 months away from utilizing the resources that we needed to rescue or recover baby Evelyn.
Okay. How old were you told Evelyn was the time the investigation began?
15 months.
Okay. What was your role in the investigation?
Of course, as a lead agency, I always stay in contact and communication with all my detectives and everybody that was responded to this scene and responded to all the tips across pretty much the region. So, I was constantly in communication with TBI, FBI, and my detectives.
Okay. If you had to give an approximate number, how many Sullivan County employees do you think were tasked with working this investigation?
Aside from my executive staff, which is about 14, we had probably an additional 40 worked around the clock just on this case.
Okay. When you say around the clock, was there 24/7 coverage
Yes, ma'am.
of this? And are we talking about from the day she was reported missing until the day that she was found?
Yes, ma'am.
It's a
Okay, and again, if you want the timeline, it's all on the playlist for you. Not all that, thanks for your sticker. The defense attorneys are there to protect the Constitution, so I completely understand their job. Sometimes, of course, if they resort to victim blaming, then we get very snarky, but otherwise not. In this case, they didn't do that. Thank goodness.
approximately 18 days.
Yeah, from about February 18th till March 6th, I looked through our records, and just overtime hours alone on this case was 740 hours.
Okay. And that's employees working their regular shifts plus overtime?
Plus
essentially.
overtime.
Okay. So let me ask this first. Did Sullivan County end up requesting the assistance from other agencies?
Yeah, this was a unique case. Normally we work most cases on our own, but we had to pull resources from the Tennessee Bureau of Investigation, Federal Bureau of Investigation, Virginia State Police, SBI.
What is the SBI?
State Bureau of Investigation, and then we had Tennessee Wildlife Resource Agency, and then multiple local regional jurisdictions up in North Carolina and other states in Middle Tennessee.
Okay. And is that essentially from following tips that were coming in?
Yeah, anything that came through, we followed every lead, tried to look into everything that was brought to the VCC, which is the Virtual Command Center through Tennessee Bureau of Investigation.
And is the Virtual Command Center, that's where the tips would come in to decide how to then send them back out to be investigated?
Yes, ma'am.
Okay. With these different agencies and with Sullivan County, what types of resources were you able to, what did you utilize to try to find this baby?
We utilized every resource that I've ever even been involved in that was at our disposal. I mean, we took jets to different places to expedite the finding of any type of information that may lead to the recovery of Evelyn. We utilized everything the TBI and FBI provided us with, just anything that was at our disposal. And we probably used more resources for this than anything I can ever remember.
We know that one of the stories, false reports that the defendant gave was that a person by the name of Ethan Perry had Evelyn. What did you have to do in regards to following that lead? What resources were used?
Yeah, he was in the military in Louisiana from what I remember, and we had to send some detectives up there as well.
Okay. And we know another story that she gave was that she kept hinting at Mendota, Virginia, over and over. Is that a lead that you also use resources to follow?
Yeah, United States Marshal, I left that out. United States Marshals helped us out on that one in Mendota.
Okay.
Oh man, and just when we thought we won't hear Mendota again, during the trial we were all like, no more Mendota, because Megan Boswell just the whole time made up stories and lots about Evelyn being in Mendota. Oh my goodness.
She also told you that Angela Boswell, her mother, had Evelyn at some point. Did you follow that lead?
Yes, we worked extensively on that one. We thought that she may have had custody of baby Boswell, so we that went into North Carolina, and I think the dive team went into the ponds over there as well.
Okay. So in preparation for today's hearing, you were asked to review Sullivan County records regarding this investigation, is that right?
Yes, ma'am.
And the records that you reviewed, were they all maintained by the Sheriff's Office?
Yes, ma'am, just the Sullivan County Sheriff's Office.
And the purpose of those was to come up with the manpower that was used?
Yes, ma'am.
To get an approximate amount of manpower and overtime hours, is that right?
Yes, ma'am.
What if the defendant had told the truth on day one?
Yeah,
Objection calls for speculation.
I could ask you in a different way. Would you have found Evelyn if the defendant had told the truth on day one?
Objection
Yes.
calls for speculation.
Sustained. It needs to be framed. It's too wrong.
If you had known that Evelyn was dead on day one, would that have changed the way you conducted your investigation?
Absolutely.
Okay. Would all of these resources have been used?
No, ma'am.
Were you aware of community involvement during the time of this investigation, the 18 days of investigation?
Yeah, extremely. They really provided us a lot of additional resources that not criminal justice related, just like they brought us food to the office so we could eat and still work, and they all pulled together during that time and just showed tremendous outpouring of support for our entire agency. And across the nation, really, this was a national recognized case. So the people around here in the community, they started Evelyn's Army, and they provided food for us daily.
Based on your own personal observations, what did the impact on the community look like to you?
Very emotional, just like my staff. I mean, everything you see, people wanted to find this baby, and that was their number one goal. And whatever it may take, whatever it may need, whatever resource may need to be utilized, everybody was willing and able to put in their time, effort, and energy to locate baby Evelyn. And just like my staff, I mean, the emotional toll on them, the lack of sleep, but they never did get fatigued. I tried to send some home, and they said, "No, I'm not going home. I'm going to work on this case until we find the baby."
Okay. No other questions? Please
Thank
answer
you.
any questions Mr. Scott has for you.
I don't have any questions.
Thank you.
Stay with call, take the math price.
Sit on the swear affirm testimony about the truth, the whole truth, and the truth. Yes, sir.
Your Matt Price, is that correct?
Yes, sir.
What is your position at the Sheriff's Department?
I'm Lieutenant in Criminal Investigations.
All right. And Lieutenant Price, you very familiar with the investigation involving the disappearance and death of Evelyn Boswell, is that correct?
Yes, that's correct.
What was your role in the investigation?
This case was assigned to me as the lead investigator with the Sheriff's Office. So I was the lead investigator.
All right. And you worked, the Sheriff has testified to, you worked hand in hand with numerous agencies in the investigation, including the TBI, is that correct?
Yes, that's correct.
Okay. And Agent David Gratz at the time, also the two of you
Worked it.
worked extensively.
Yeah.
That'd be
Yes.
correct. You familiar with the evidence that was collected in the case, the discovery of the body of the victim, Evelyn Boswell?
Yes.
Lieutenant Price, I'm going to hand you some photographs. I'm just going to do this one at a time so for the sake of getting these exhibits in. I'm going to hand you the first photograph, ask you if you can show us, identify what's shown in that photo.
Yes, this is a photograph of looking inside the playhouse at the trash can where Evelyn was located.
And is that a true and accurate depiction of
Yes.
that scene?
Okay.
Judge, we would just make that exhibit number 1 to this hearing. 2, I'm sorry. And I don't know if it's helpful, but that was what the trial was introduced as exhibit number 15. I don't know if that's helpful or would create confusion or.
It'll be exhibit 1 from that sentence.
Two.
Quick pause. Southern Calibre said, "Is that a new prison tattoo on her finger?" I think so. It looked unfamiliar to me when I saw that. It's like on her middle finger, right? Interesting. And also Amanda said the side eyeing her own counsel is giving her. Did you see that as well? I was like, oh, just glaring at her.
You recognize what's shown in the photographs just handed to you?
Yes, I do.
What is that?
Again, this is looking inside the playhouse at the trash can after the one of the bags had been removed off the top.
Okay. Is there anything of significance that you see as you look at the trash can itself?
Yes, it appears that the items inside the trash can have been compressed.
Judge, we would move to make that exhibit 3 for this hearing. Okay. Lieutenant Price, would you take a look at the photographs being handed to you and ask if you can identify what's shown?
Yes. This is a picture of the inside the trash can with the blanket removed where you can see baby Evelyn's leg.
Is that the first shot or first, I guess,
Yes.
discovery of the body?
It is correct.
Judge, we think that exhibit 4 for this hearing.
Oh, they got to be careful with those pictures. Sure. They're very graphic. Okay, so there's the tattoo in question. I see Pernille said, I believe she had the tattoo all along. I just can't remember it. And Rion70 said she had the tattoo at trial. So thank you so much for clarifying. Maybe I just missed it. Some of us missed it. We're not sure. Is that new or not? Okay, she had it. So this is Megan Boswell, who's here at a sentencing hearing, to be given even more time, potentially, depending if that's concurrent or consecutive, on top of life with the possibility of parole after 51 years.
Do you recognize what's shown in that photograph?
Yes.
What is it?
This is the trash bag that was inside the trash can where baby Evelyn was located, and also the child is with the aluminum foil and the blanket is laying beside the trash bag.
No. So the body has been removed from the trash
Correct.
bag.
The body's been removed from the trash bag. It's in the trash bag with trash in it. Baby Evelyn is laying there wrapped in blankets and aluminum foil wrapped around her.
Judge, we would move to make that exhibit 5 this hearing. Do you recognize what is shown in the photographs that's been handed to you?
Yes, I do.
And what is that? A picture of it.
This is the body of baby Evelyn after she was removed from the trash can, placed inside of a body bag. She's lying there with blankets wrapped around her and aluminum foil wrapped around where her head area was.
Judge, we would make that exhibit 6 to this hearing. Do you recognize the photo that's just been handed to you?
Yes, I do.
What is shown in that photo?
And this is baby Evelyn laying in, still wrapped in blankets, laying on a body bag, with her arm exposed, showing the onesie that she was wearing.
All right. Is that photo, one of the photos that was taken at the time the body was recovered?
It is correct.
Judge, we would move to make that exhibit 7 to this hearing.
This is Prosecutor William Harper. Today there's no jury. The jury's done. They were done in February, right? She was found guilty on all counts, and they recommended a sentence for the first-degree murder charges of life with parole after 51 years. And so today, more time will probably be added to that based on the other 16 charges. Gamto said, I remember the day or night they found Evelyn. WJHL was there, and you could hear Tommy's wife screaming out. Oh man.
Lieutenant Price, do you recognize what's shown in that photo?
Yes, I do.
What is that?
This is baby Evelyn after the blankets and aluminum foil have been removed from her body. It shows the positioning of her head and how she was laying when the blanket was removed.
Judge would move to make that exhibit 8 in this hearing. Finally, Lieutenant Price, can you do one more photo and ask me you to identify that photograph, please?
Yes, I can. This is a picture of Evelyn, one of the last known pictures we know that when she was alive.
Judge, we could make that exhibit number 9 in this hearing. Thank you, Lieutenant Price. If you would answer any questions Mr. Scott has for you.
No questions, Judge.
That's all the evidence to say.
Judge, Mr. Boswell would like to make an allocution.
Okay, we did not expect this at all. An allocution. A formal statement made by a defendant in court, typically before sentencing, where they have the opportunity to speak directly to the judge. Wow.
I would just like to say that the state of Tennessee treated me very unfair during this whole investigation. And had I had a fair trial and an impartial jury, I would have been acquitted of the murder charges. I would have never hurt my baby, and I did not kill Evelyn. That's all.
Don't mind me while I eye roll. Still no responsibility, huh? See, the judge would consider that. Has she taken responsibility for the crime? No. Oh, so the jury. So you're saying you didn't have a fair trial, and the jury found you guilty, a sequestered jury, of 19 counts, but they got it all wrong, right? She would never. But you did. They proved a lot. It was her fingerprint on the foil, her DNA connected to the trash can, to everything. No one else is. What? Okay, you guys are all freaking out like me. I'm glad I'm not alone in that.
I'm sorry.
She sure can turn those tears on and off, eh?
Judge, the state has, prior to this hearing, filed a notice of intent in regards to enhancing factors that we believe apply, as well as a notice of intent to seek consecutive sentencing, which is what we are asking the court to do. And we believe, based upon the seriousness of the offense, as well as the fact that Miss Boswell is a dangerous offender whose behavior indicates little or no regard for human life, that she had no hesitation about committing a crime in which the risk of human life was high, that this court should run those sentences consecutive to each other. And I want to touch briefly on the enhancement factors, and primarily on the one that I think just screams out in this case, which is the violation of trust. Truly, I think the facts that were involved in this case, and the court, of course, consider everything that was presented and that came in at trial as well as the photographs that have been introduced to the sentencing hearing, which again, those were all part of the trial evidence as well. But the trust that Miss Boswell betrayed upon her daughter was just so callous. She chose herself repeatedly, time and time again, over her child. All deaths are horrible, but for a small child to die in the way that Evelyn died just shows such extreme callousness. And those photographs show you. I mean, she was discarded like a piece of common garbage. Detective Lieutenant Price testified to, it looks like the body has been compressed, pushed down in the trash can so we can fit more trash, more garbage on top of a child. But probably the most hurtful and severe part of this whole and painful part of this is the fact that all that occurred at the hands of the one person that she should have been able to rely upon and trust to protect her own mother. But Megan didn't do that. Megan repeatedly chose Megan. Megan chose her life. Megan chose living in a big house out by the lake. Megan chose going to the movies. She chose going to Blowing Rock, going to Gatlinburg, again and again and again, over her own daughter. In order for the court to find that the defendant was a dangerous offender and apply consecutive sentencing, there are two things that the case law has said the court has to find. One is that it relates to the severity of the crime. And I can think of nothing that would be any easier than to relate consecutive sentencing to the facts of this case and what Ms. Boswell did. I mean, not only did she murder her own child and then go about her own life, but then once law enforcement was finally brought into the case, not because of her, not because she did anything, but because it finally got reported by her dad. Well, then she manipulates law enforcement, manipulates the community by continuing to lie over and over and over again, causing extraordinary resources to have to be involved for weeks trying to find this child in the hopes that she's alive. And then even after that, even after she finally coughs up the fact that her child is dead, she continues to lie about not knowing where she is. When all along, she's sitting there stuffed upside down in a trash can in her childhood playhouse. So I think it's very easy for this court to find that the severity of this crime and her suffocating her own child, putting her in a trash can, and then repeatedly lying about it to cover it up relates to the severity of the crime. The second finding this court has to make is that it was necessary that consecutive sentencing was necessary to protect the public from further crimes. And provided the court, as well as Mr. Scott, with the case of State v. Taylor, which was a case in which a small child had been beaten to death, and then the mother basically delayed in reporting, calling 911, which eventually resulted in the child dying because she didn't receive any medical attention. And the court in that case found that the dangerous offender classification was satisfied because the defendant had demonstrated extreme callousness towards the health and welfare of the victim, and the results were fatal. Well, Judge, it does not get any more callous than what the defendant did in this case. She turned her back, she turned her life, she turned her trust away from her own child. Evelyn got in the way of the life Megan Boswell wanted to live, and so she eliminated that problem. It truly does not get any more callous than that. So the state would submit that both those factors are met and that the court should impose consecutive sentencing. I've already touched on the element as far as trust being involved in an enhancing factor. And then sitting here listening to Ms. Boswell's rather brief allocution, I think it's also right for the court to consider the fact that she sits here today in this courtroom still having absolutely no remorse and taking no responsibility for the death of her child. Once again, she wants to make all of us victims in the case, make herself a victim. Sheriff's office, I guess, should be issuing an apology to her for the way she's just been unfairly treated during this whole process. Judge, Miss Boswell was not treated unfairly. Her child was treated unfairly. Her 15-month-old child never had a chance because of the one person who should have protected her. For that reason, the state is asking you to maximize her sentence in the remaining counts that she has to be sentenced on, and we would ask that they be run consecutive, Judge. Thank you.
We want life without parole, right? Please.
Judge, I guess I'll try to address this in somewhat where Mr. Harper did, maybe the back of his fashion. Ms. Boswell had no prior criminal history when this case started, when the investigation started. At some point, she was convicted of a reckless driving B misdemeanor in Washington County, I think in February of 2020. That's the only criminal history she came to this court. She's been in jail since she was 18 years old. She will be in jail if this court were to sentence her at the low end of everything and not run it consecutively. She'll be in jail until she's 69 years old. So the court then has to determine, at that point, is she going to be a threat to society? Does society need to be protected from 69-year-old Megan Boswell? The court should, I guess first the court has to consider the length of the sentence. She's a range one offender as to each count. The court should impose I think the sentence short of a sentence is as necessary, so the court is supposed to do to achieve the purposes of sentencing. Here, she's serving a life sentence. She will be eligible for parole at 69 years old. So how much more do you need? Essentially, the state asks you to sentence her to life without parole. That's what they want. And we have addressed that issue already in a manner of speaking. I guess, practice law 25 years, I'm still in jury sentencing, I've ever done it. But the jury had the opportunity, after hearing all these facts, to consider whether to sentence her to life without parole or life with parole. They sentenced her to life with parole. Now, I know you're not bound by that on these other counts.
I'm just going to pause there. I've boosted it more because he's very soft now. I don't know where his microphone went. But just be prepared for the court cougher. I don't know if it came from the state's desk or what, but that was loud. So don't blame me, okay? We got a boost to hear the defense attorney. If anybody coughs or flaps papers over here, it might be quite loud.
I think in fairness and in deference to that jury, we have to give some respect to what determination they made. And they were aware of all the other charges. Obviously, they heard the guilt phase and those who convicted her. So I think that is important to consider. She's eligible for probation on all the other charges. The court has to make a determination whether or not those sentences should be suspended or served. The court has to make a determination whether, if they are served, how they're served, consecutive or concurrent. As it relates to the dangerous offender who society has to be protected from, I think the case law is quite clear. Not every person convicted of first-degree murder and another felony is going to fall into that category. Normally, in a lot of the cases you see multiple victims, multiple acts. Here, all those things kind of go together. And I guess the other thing we have to talk about is what counts merged together in this sentence. I would suggest to the court that the murder counts merged together for one count. That the child abuse and child neglect counts should merge. And that all of the following false reports should merge. Because I sent a case to you yesterday. State versus Smith, 436 Southwest 3rd, 751. Tennessee Supreme Court decided that in 2014. It talks about cases just like this. In each of these cases, these interviews were basically a continuation of the other interviews. And based on the rule of leniency, the court found that even though in that case interviews were made over multiple days with different officers, just in this case that they had to merge. And that's what I think should happen here, is all those counts should merge. And I guess finally, I want to address what Mr. Harper said about Ms. Boswell's comments. I think a lot of defendants would probably feel that way. But I think she's entitled.
There's definitely a microphone that's taking center stage instead of where the other one. We just heard somebody swallow, we've heard coughing, so sorry about that, but we're trying to hear as best we can what this defense attorney is saying. Of course, he wants minimal time for his client. And the state wants max, and I'm with the state on this one. Max, please. Is LWOP a possibility? Yes, then we want that.
To maintain her defense. She doesn't have to come in here for purposes of sentencing and somehow take responsibility. The law doesn't require that. That's not one of the factors to consider for consecutive sentencing. That's not one of the factors to consider for convicted sentence. The defendant has a right to maintain their innocence. And to hold that against them and to somehow sentence them to more jail time because they come in here and say, I did it, that violates due process. It violates the right to trial by jury, the right to appeal. So I would suggest to the court that the appropriate sentence here should be bottom end of the range. The sentences should run concurrent, and ultimately she should be left with a chance of parole when she's 69 years old, however that is structured.
How about no?
Court will be in recess for 15 minutes.
Oh boy.
Determining
the appropriate sentence for these offenses. The court has considered the evidence presented at the trial at this sentencing hearing. Pre-sentence report filed April 4th, 2025, more than 10 days ago. The principles of sentencing and arguments made at sentencing alternatives, the nature and characteristics of the criminal conduct involved, the evidence and information offered by the parties on mitigating and enhancing factors, any statistical information provided by the administrative officer of the courts as to sentencing practices for similar offenses in Tennessee, located at www.tncourts.gov, and any statement the defendant has made on her own behalf about sentencing and the defendant's potential for rehabilitation or treatment. I'm not sure if it was agreed, but the defendant's a range 1 standard offender under Tennessee felony classification laws. And what that means, the aggravated Aggravated child abuse and neglect charges are Class A felonies, and as a range 1 offender, those would carry somewhere between 15 and 25 years. The tampering with evidence is a Class C felony. The range would be between 3 and 6 years. False reports are Class D felonies, with a range 1 being 2 to 4 years. The abuse of a corpse is a Class E felony, and failure to report death under suspicious, unusual, or unnatural circumstances, also a Class E felony. Those Class E felonies for range 1 would be a range of 1 to 2 years. In determining where the appropriate sentence should be within that range, while not mandatory any longer, the enhancement factors and the mitigating factors are advisory for the court. The state has urged in its filing state's urged number 3, enhancing factor 3, that the offense involves more than one victim. I think for purposes of this case and all the proof that I heard, I can understand how that argument could be made, but I'm not going to find that enhancing factor number 3 applies. Enhancing factor number 4 is urged by the state. A victim of the offense was particularly vulnerable because of age, physical or mental disability. I think that will apply. Testimony was that baby Evelyn was, everybody keeps saying 15 months old, but I think she was 15 months old when she was found. My recollection of the proof was that she was approximately 13 months old when she went missing.
Yes.
Is that wrong?
She was, her approximate age at death was 15 months old.
At death?
At death.
Okay. So she was 15 months old.
I'm not sure why they say that, because if she was born, sorry to pause there, I think the judge is correct. If she was born on November 21st of 2018, and she was last known to be alive around December 6th of 2019, do we do the math? She was 15 months old when reported missing in February by her grandpa. But the judge is right, so come on, state, the judge is right. It could impact the sentencing. She was only 12 months old. She was one year old, if that date of birth is correct.
It was 13 years, 13 months old at death. It was 15 months old. They assumed when she was reported.
Thank goodness. Yes, Judge, you are
When
correct.
they didn't know she was alive or dead.
So at the time of her death, she was somewhere between 13 and 15.
Yes.
The state has, and the court accepts enhancing factor number 4. Number 5 is urged by the state. The defendant treated or allowed a victim to be treated with exceptional cruelty during the commission of the offense. I don't know, and I'm not going to sit here all day and regurgitate the facts from the 11-day trial. But thinking back on the proof that I heard, there can be no more cruel act than to stuff a 13 to 15-month-old baby wrapped in blankets and aluminum foil head first into the trash can. Especially when that 13 to 15-month-old baby is your baby. So the court accepts number 5. Number 6, the personal injuries inflicted upon or amount of damage to the property was particularly great. The court accepts number 6. There's no greater injury that you can inflict on another human being than death. Enhancing factor 10 was in the filing. Defendant had no hesitation about committing a crime when the risk to human life was high. The court accepts number 10. And then 14, the defendant abused a position of private trust. And again, the relationship between mother and child, there can be no greater private trust on this earth than that. So the court accepts number 14. Those are all the enhancing factors that were urged, all the ones that the court, after having looked through them, believes applies. Next, I have to consider mitigating factors in determining the appropriate length of sentence. And again, I'm not going to read, there's 12 statutory mitigators under 40, 35, 113. I'm not going to read all of these in. The defense didn't put any arguments forward as to any mitigating factors that should apply. The court, though, is required on its own, after having read the pre-sentence report, heard the proof, to apply any factors I think are applicable. So there's at least one that could be applicable, and I'm going to talk about it for a moment. That the defendant, because of youth or old age, lacks substantial judgment in committing the offense. The proof is that she was 18 when the killing occurred. But I also have to look at, so there's no question that she was a young adult. But I also have to look at all the other proof and circumstances surrounding the case. And it became very clear to the court, upon hearing the evidence, that the defendant, in her mind, saw a chance to lead a different life than what she thought she was going to be leading. And quite frankly, circumstantially, from all the proof, baby Evelyn was a stumbling block to leading that life. So she made the decision to remove that stumbling block. And because that's the tenor of the proof that this court heard, I reject mitigating factor number 6. She exercised judgment. It wasn't good judgment, but she exercised judgment in doing the things that she did. So of the 12 statutory mitigators, the court doesn't find that any are applicable to this case. The 13th is any other factor consistent with the purposes of the chapter. And courts regularly, if a person comes to the court without a substantial criminal history, courts regularly include that as factor number 13. If a person comes before the court and they've had a long, productive work history, then that factors into 13. If they've had military service, those are the kinds of things that factor into 13. In this case, Ms. Boswell, she did not have a long work history. In fact, the pre-sentence report said, she stated that she'd only ever had one job in her life, and that was at the chicken shack where she was working right around the time of this killing. I am going to give her credit for not having, even though she was only 18, I'm going to give her credit for not having a substantial criminal history, either as an adult or a juvenile. So, the court weighs all the facts that I've heard during the trial, all of the testimony that we've heard at this sentencing hearing. When the court weighs the enhancing factors and the mitigating factors, that's how I arrive at a verdict, or not a verdict, but a sentence. I do want to talk, and I'm going to talk about each of these counts individually with regard to the enhancing factors. Because if an enhancing factor is part and parcel of a charge, then it can't be used as an enhancing factor. So for count 4, aggravated child abuse, the state has to prove that the defendant knowingly, by other than accidental means, treated a child under 8 years of age in such a manner as to inflict serious bodily injury. The court is of the opinion that number 4 still applies because of the tender age of the child at the time. It's one thing to be a child under 8 when you're 6 years old or 7 years old. It's quite another thing to be vulnerable because your age is still literally being counted in months. So the court finds number 4 applies. Number 5 is not an element, it applies. Number 6 applies due to the death is not an element of aggravated child abuse or aggravated child neglect. 10 and 14 apply. So the court finds that they all apply to counts 4 and 5. So the court's of the opinion in that Class A felony that the enhancing factors and the aggravated nature of this case in general take that sentence from 15 to 25 years. And when the court weighs, and quite frankly, each of these enhancing factors, with the exception, number 4 has low weight because of its similarity for those 2 counts, to the charge. 5, 6, 10, and 14 have great weight. The court affords very little weight to the fact that Ms. Boswell, at 18 years of age, had no serious criminal history. So the court's of the opinion in counts 4 and 5 that the sentence should be 25 years. The court's also of the opinion that count 5 merges into count 4. In the tampering with evidence, the court's of the opinion that all the enhancing factors should be afforded great weight, and the sentence should be 6 years. The mitigating factor, which is the court's been giving very little weight, would not bring it back down. Now, with the false report, the court's of the opinion that the enhancing factors would take that sentence from 2 up to 4 years. And again, there being only the one consideration of the mitigator, it'll be 4 years. Under the case of State versus Smith, Tennessee Supreme Court, 436 Southwest 3rd, 751, handed down in 2014. Justice Holder, I believe, delivered the opinion of the court. And the opinion of the court was that due to the principle of lenity, not leniency, that a false report, because the legislature was ambiguous as to how they think that a false report should be punished, that the unit of prosecution isn't determined by the number of individual and distinct occurrences of false statement, but that the unit of prosecution is whether a false statement was given pursuant to a particular incident or offense. At least that's the way I read it. So it wasn't that it's a continuation of the interview. It's that the incident that is in the officer's concern is the disappearance of the child. And the Supreme Court says in that case that even if you tell 16 false statements about the disappearance of that child on different days and to different people and different variations of the story, it's still one incident. It's the disappearance of the child. So counts 7 through 17 all merge into one count. So they all merge. Counts 8 through 17 merge into count 7. In count 19, the court said the opinion the enhancing factors take that sentence from 1 up to 2 years. So that'll be a 2-year sentence. In count 20, and again, I'm weighing the lack of mitigators. In count 20, that sentence will be 2 years as well, for the same reason. Now, since I've already talked about merger, the court said the opinion that counts 1, 2, and 3 would all merge into a single life sentence. So counts 2 and 3 merge into count 1. Now we'll talk about consecutive sentencing. In the state's filing, the state under 40-35-115 urged, and I think this might be a mistake, but urged number 2, that the defendant is an offender whose record of criminal activity is extensive.
And of course, ruling, I just so clarify, it wasn't a mistake, but at the time it was filed, I believe we would have all the false report counts to rely on past criminal history. Obviously, since the court's found that multiplicitous, that doesn't exist anymore, so we're not relying on that one.
The court objection. But the court also relies on enhancer number 4 from the same statute, 40-35-115, that the defendant is a dangerous offender whose behavior indicates little to no regard for human life and no hesitation about committing a crime in which the risk to human life is high. Now that's what the factor says in the statute. But as pointed out in State versus Taylor, (2017) Westlaw 2179952, also case numbers M 2015-02142-CCA-R3-CD. It's an unpublished case, but the unpublished case references published opinions. And the most important one that it references is State versus Moore, that quotes from the big main case is the Wilkerson case, 905 Southwest 2nd, (933) Tennessee Supreme Court from 1995. And the Supreme Court, in determining the appropriateness of 4035-115, enhancing factor number 4, states that in addition to what's stated in the statute, that a court must also find that a sentence, consecutive sentencing, is necessary in order to protect the public from further misconduct by the defendant, and that the terms are reasonably related to the severity of the offense. So, from the facts of this case, and again, I'm not going to just keep repeating it. Everybody who sat through that trial knows the facts that came in. The testimony during the trial was that that child was suffocated. And when you look at the pictures of how tightly this baby was wrapped in blankets and aluminum foil, and the mechanism of being stuffed into that trash can head first, there's no doubt in my mind that this defendant had absolutely no hesitation when she killed her daughter. And in hearing the proof during trial of how she continued to live her life, and from hearing the proof circumstantially as to why she might have done this deed, because this new boyfriend is the life that she wanted to grasp onto. It's like the state said, the house on the lake, a lifestyle that she wanted for herself. The fact that Evelyn was just in the way. And looking at all the video that we saw during the trial, this court never once saw remorse, never once saw empathy out of the defendant. So she is a dangerous offender. The circumstances surrounding the commission of this offense are absolutely aggravated. This baby couldn't care for herself. This baby had the only life this baby knew. The only way this baby could get through a day was through her mom. And I understand that the way the parole system is set up when dealing with a life conviction is that she has to serve 51 years before she's even eligible for consideration for release. And Mr. Scott asked the question during his argument, which was the right question to ask. Is Megan Boswell at 69 years of age coming out of prison a risk to society? And the only conclusion that I can come to after hearing the proof in this case, seeing the evidence in this case, seeing how utterly unconcerned with the fact that she took the life of a 15-month-old child, her own child, the court has to answer that question, yes. That society does need to be protected from the evil that lurks in her heart.
I love it, Judge. Yes.
And then would the aggregate length of the sentence reasonably relate to the offense which she stands convicted? For the same reasons I just said, yes is the answer. So the court finds that all those sub-factors, if you will, are met. And I want to read a passage. And I think the state may have, but I highlighted this yesterday when I read the case. In State versus Durantes, 331 Southwest 3rd, 370, at page 376, the Tennessee Supreme Court in 2001 found that the dangerous offender classification was satisfied where a defendant demonstrated extreme callousness toward the health and welfare of the child victim, and that the results of that callousness were fatal. It's almost as though that passage was written to describe this case. Therefore, the 25-year sentence for the merging counts of aggravated child abuse and neglect will be consecutive to the life sentence. The 6-year sentence for tampering with evidence and the 4-year sentence for false report will be concurrent with each other, but consecutive to the 25 years. And the 2-year sentences for the abuse of corpse in count 19 and count 20 will be concurrent with each other, but consecutive to the 6 years. So in counts 4 through 20. That'll be a 33-year sentence as a range 1 standard offender, consecutive to her life sentence. The court has considered probation. She's not eligible for probation on the Class A felonies. That 25 years has to be served by statute. The court has considered probation on the additional 8 years and finds that a grant of probation would depreciate the seriousness of this case, given the facts of this case, given the fact that she has shown no remorse, she has shown no empathy towards this child, her child, and probation in those counts will be denied. Mr. Scott, I believe at sidebar you had indicated that you would like to have a transcript prepared before, in order to prepare the motion for new trial.
Yes, Judge.
I'll order that transcript, whatever order I need to sign, share, I'll do it.
Judge, I would also like to have this sentencing period as well.
Sentencing hearing will need to be typed up as well. We'll set this for status. We'll send Ms. Boswell back to TDOC.
All right. Yes,
And
please.
let's set this for a status on January 16 to see where we are on getting the transcript prepared.
That's fine, but I'll waive Ms. Boswell's appearance at that.
Well, what I prefer her to do is appear by Zoom.
That's
If
fine.
she can, but if not, yes, we can.
Okay.
All right. All right, that's all.
So basically, she's never getting out. Bye, Papa. Look at that attitude. Can you imagine? Where's Kyle? Kyle the bailiff. Good job to everyone, right? Let's just see what else they're doing here. Excellent. We'll recap now for a moment. Okay, that seems like the end of the sentencing hearing. So basically, what I could understand, because I'm scribbling down everything the judge was saying, is that she's never getting out. Okay, that's the gist of it. So she already in February was sentenced to life with the possibility of parole, but only after serving 51 years. And then she was given credit for the time that she had already served, right? Thank you so much, Shauna. And then today, the judge said that the life, he said life plus 25, so count 1, 2, and 3, life plus 25. Then he said for the counts that was, it was count 5 and another one, which was 6 years and 4 years, that would be concurrent, but consecutive to the 25. And then the other counts also consecutive too. So he merged some, but when he merges them, then he adds on consecutive. So she's never getting out. You know, I'll put in the pinned comment once I have confirmation of exactly, you know, how much she will have to serve before she's ever eligible for parole. But I think based on the math, she's never getting out. She has to serve 51 years plus all of this time now, which initially when he went over it, I had counted, so wait, let's say if this is together, so let's take the maximum there. 25, 31, 33. So if we even just do that, it would be like 84 years. Here we go. Sharon, you also. Additional 33. 84 years before she's eligible for parole. And she is 23 years old now. So, I mean, 23 or 24, right? plus 84. Yeah, no, she's going to have to live a very long life to be able to ever be eligible for parole. Can you imagine? Sarah says, it's been 84 years. Yeah, that will quite literally be her. That's a Titanic reference. It's been 84 years. That's that's what she's looking at. Thank you. Julie Merrington as well said 51 plus 33 equals 84 years. I like how you guys also, were you also scribbling? Were you also calculating? Thank you so much for helping me to do that as well. That's, I'm glad we're all coming to the same answer. That helps. Let's hope we're all right. And Charlie said, I make it 84 years before parole. Sure, thank you. Justice for Evelyn was served. This judge, I really like this judge. He's very he's very snarky, you know, but he's really good. We saw him throughout the trial. Sometimes he can get upset with things, but it's because he's protective of the case, of course, right? And he didn't want, like, when there was a moment, which was a mistake, when the jury was shown for a second, I mean, yeah, he was very upset with that. Pulled the cameras from the courtroom. Why? To protect the case. So, I mean, yeah, this dates back to 2019, actually. So to be here in September of 2025, this is September 5th of 2025, and all the sentencing is now complete for Megan Boswell. She was already sentenced on some charges in February 2025, and now the sentencing is complete on all 19 charges. Life with the possibility of parole after 84 years. Wow. Okay, might as well be LWAP, you know. So anywho, I can't believe what she said today on the stand. Like, really, the audacity. You're really going to get up there and say that crap? Really? So again, if you want to deep dive this case with me, we've done so. It's on the playlist. The playlist is linked in the description box for you. You can find not only trial prep videos, but after the post-trial videos as well with detailed timelines. You can find the trial as well. It was only an 8-day trial, of course, excluding the jury selection. The judge said 11 days, so that would include the jury selection. And as I said during the chat, during this live stream, the jury deliberated for 4.5 hours. And they found her guilty on 19 counts. And yet Megan wants to get up there and say she didn't get a fair trial and the state's been treating her unfairly and she would have been acquitted if it wasn't for all that. Like, really? Wow, interesting. Okay, so thank you so much for watching the sentencing with me. It's nice when a trial is like complete and sentencing is done and justice is served. I mean, just look at little Evelyn. Shame, man. She didn't even get to, she only had one birthday, like her whole life. I mean, she had a terrible life, actually, and so short. And the way that she died is absolutely horrific. Deborah, thank you so much. Thanks all for your support. Remember to check if the like button works. How do you check it? Just tap it once. Just see if it works. That always helps as well to support the work I do. If you wouldn't mind sharing this as well so that people can catch up on this update, because it's been 6 months waiting for the sentencing. So I'm really, really glad that we were able to see that. Of course, thanks to Court TV for having cameras in the courtroom. That's always helpful so we can watch it together. Stephanie King said, this is the case I became a Grizzly on. Justice for Evelyn. Thank you so much, and thanks for still being here. I really appreciate it. If you feel like you're having trial withdrawal, please rewatch this trial if you haven't seen it before. There's also many other trials I've covered before, and do rewatch some of those, right? And thank you, mods. Thank you, everyone. I wish you a wonderful Friday. Maybe some of you already in Australia, Tokyo, somewhere. Maybe it's Saturday already for you. But I wish you a wonderful weekend. I will definitely see you. There's been lots of news, of course, in true crime. So I will see you again very soon. In the meantime, stay safe.